Hey everyone, welcome back to the channel. In today's video, we'll be discussing an important distinction in contract law, the difference between an offer and an invitation to treat. We'll also dive into one of the most famous cases in contract law, Carlill and Carbolic Smoke Ball Co. If you have ever wondered what makes a legal offer and how it differs from a mere invitation to treat, this is the video for you. In legal terms, an offer is a clear and definite promise to be bound by specific terms, which, if accepted by the other party, forms a binding contract. The key point about an offer is that it indicates a willingness to enter into a contract upon acceptance. For example, if I offer to sell you my car for $10,000, I am making a firm commitment that, should you accept it, I am legally bound to follow through with the sale under those terms. What are the key characteristics of an offer? Number 1. It is specific and contains definite terms. Number 2, it expresses a clear intention to be legally bound upon acceptance. Number 3, once accepted, the offer turns into a legally enforceable contract. On the other hand, an invitation to treat is merely an invitation for others to make offers. It indicates a willingness to negotiate but does not constitute an offer in itself. Common examples of invitations to treat include advertisements, price lists, and goods displayed in a shop. For example, when you walk into a store and see an item on the shelf with a price tag, that's not an offer by the shop to sell it to you. It's an invitation for you to make an offer to buy it. The store can then either accept your offer to buy that item or reject your offer. So the key characteristics of an invitation to treat are that it invites negotiation or the making of offers and are not legally binding in itself. Examples include advertisements, auctions, and tenders. The main difference lies in the intention of the party making the statement. An offer shows an intention to be bound by a contract once accepted. An invitation to treat is simply an expression of willingness to negotiate. Now let's talk about the famous case that highlights this difference, Carlill and Carbolic Smoke Ball Co. The Carbolic Smoke Ball Co. advertised that they would pay £100 to anyone who contracted the flu after using the smoke ball as directed. They even stated that they had deposited $1,000 in the bank to show their sincerity. Mrs. Carlill bought the smoke ball, used it as directed, but still contracted the flu. She claimed the £100, but the company argued that the advertisement was not a binding offer, but rather an invitation to treat. The Court of Appeal disagreed. They held that the advertisement was an offer because it contained specific terms and demonstrated a clear intention to be legally bound, especially since the company had deposited money in the bank to show their commitment. So, an advertisement can be an offer if it shows an intention to be bound upon the fulfillment of certain conditions. In this case, the deposit of £1,000 in the bank was a strong indication that the Carbolic Smoke Ball Co. was serious about their offer. So there you have it, the difference between an offer and an invitation to treat. Remember, an offer shows a clear intention to form a binding contract, while an invitation to treat is just a preliminary step, inviting offers. Carlill and Carbolic Smoke Ball Co. is a great illustration of how an advertisement can sometimes go beyond an invitation to treat and become a legally binding offer. Thank you for watching, and I'll see you in the next video. Don't forget to like, share, and subscribe.